Good morning. How are you? Well, I've been listening in the background to the hearings about Judge Jackson's nomination to be on the Supreme Court, and so I'm taking a walk midday because I have appointments in the afternoon. Lindsey Graham is perhaps the questioner or commentator that I heard the most, meaning that I was not distracted by my actual work. And it struck me that he was using Judge Jackson as a foil to talk to the constituency rather than to address her. And by implication, by mentioning these things, there is the suggestion that somehow or other she is comparable to the example he's giving. One, of course, was Amy Barrett. He doesn't say that at first. He says, you said at the outset you're a woman of faith. What exactly is that faith? Well, see, I think that's inappropriate. And he was laying the groundwork to say, if you're uncomfortable with me asking you about your faith, why should it have been relevant in the case of Amy Barrett? And Amy Barrett made no bones about the fact that she put religion and faith ahead of the law, and that the law was an instrument for her faith. So it's not like, say, an individual has all manner of understandings of what their faith and whatever their religion is. For her, she brought her faith into the public square, if you will. She enunciated her faith, that is, that a fecundated ovum is a person already. The moment of conception is itself, that religious principle is supposed to be in our law. Not so. So that was very interesting. And so he extrapolated Amy Barrett's different set of facts and what faith meant in her life to try to draw out what were the very private beliefs of Judge Jackson. Now, Judge Jackson is obviously intelligent, adroit, can read what he's doing, and yet maintains a demeanor that is respectable and shows a gravity of a person older than her 50s. So I laugh only because I'm thinking, I wonder if I have that gravity because I'm past my 50s. But anyhow, she, I thought, dealt with each of these insulting questions in a good way. Now, one that was particularly interesting was his attacking her about Gitmo, Guantanamo, the prisoners we kept there. And these people were kept there without a description of their crime, evidence of their crime. They were tortured. They called it enhanced interrogation techniques at the time. And she was assigned to represent one or more people at Gitmo. And the Supreme Court recognized the fact that these individuals had constitutional rights in our system, being that they were at Gitmo and so forth. And they were not going to sanction some sort of rendition light, if that's what this was going to be considered. And she worked on at least 2 amicus briefs to the Supreme Court, and he asked her about that. His answer was that when these people were released, and he didn't specify that it was one of her clients that was released, but when these people were released, he said there were recidivists, 30% recidivists. Well, how they know that, and that they were recidivists, is a different question than, do you have the goods to hold them in the first place? Do you have the goods they committed a crime? And if you do not, we, under our law, cannot hold them. Do we acquit people who are guilty? Perhaps, but that's the price of reliability in our governmental functions. Are there cases you should try in which you have evidence that is strong but not absolutely beyond all doubt? Yes. And when you lose those cases, if you do, and somehow or other you find that the person is guilty, that's a different statement than to say people who've been beaten up go back and become, quote, recidivists. Recidivist says they did it before. We don't know that they did it before because you never showed us any evidence of it. Anyhow, Graham lost his cool on that one. He just went crazy. So they've turned this hearing into a political show trial of people and subjects absent from this hearing to make political hay rather than to conduct at this time when people look at our law and question it, rather than have a serious hearing that might enhance our respect for the law and for Congress. But forget that. That just doesn't happen in America anymore. We basically have, what would you say? Gangland toughs in suits on the Hill, saying things that are irresponsible, slandering people, misrepresenting the law, misrepresenting the facts, unconcerned about its effect on America when millions of people see this performance in public. Now, another senator, very interesting, he didn't seem to understand that the 14th Amendment, you know, those post-Civil War amendments to the Constitution, were the law that he was criticizing when they were revisited so much at a later time in our nation's history. But the 13th Amendment guaranteed freedom, abolished slavery. The 14th Amendment said, we're going to give privileges and immunities to you, and it's going to apply to the states as well. And the 15th Amendment said, and by the way, you get the right to vote. Now, this man who's asking this question must have been in Congress how long? And he doesn't know how our government works. Or he would misinform the nation for political reasons for his own belief system. But I'll choose just one example, and it's the one I mentioned yesterday. He says, a majority of the people voted for this. How can you throw it out? That is the point of an individual right, to assert the right of an individual to have a same-sex marriage, for example. It is the right of an individual to choose someone you would not choose as your spouse. I saw a cartoon some time ago. Man's in bed with his wife. They're all, you know, they're all covered up. It's a cartoon, remember? And he says, you know what's wrong with our marriage? That there are gays getting married. That's exactly the point. The individual right is an assertion based on our Constitution you can assert against the majority. If the majority are for racism, our Constitution now says you may not do that to an individual. They are really finally guaranteed equal protection under the law, which Judge Jackson mentioned in her address to the committee. So we see people who know the law better, or should, and should be fired if they don't, because they are supposedly the legislature. I've argued before courts and talked about some of these issues, and I've had judges on the bench who don't know it. This judge knows it. The questioner does not, or at least he's prevaricating, as we might say. Finally, let's talk about what's happening in the war in Ukraine. In Ukraine, we have a situation in which it's generally agreed by all the military experts that Putin is in a stall. And we're concerned about what he's going to do. Well, there are tactical nuclear weapons and there are chemical weapons, and that may be his next step. He may try to bomb them into the Stone Age, although they're partly there already. It's ironic because there's been a discussion about what happened years ago after Putin in 2014 decided to take all that territory. And the question was, should the United States give javelins to Ukraine? And at the time, President Obama said he didn't want to encourage Russia to escalate. Well, here we are again. We don't want them to escalate. We've given them the javelins. They're not enough. And it may be too late for anything short of a magic wand to get us out of the death and destruction that seems imminent. So that's what I got to say for the day. If you get a chance, watch or listen in the background, as I may when I finish this walk, the remaining part of the hearing of Judge Jackson, who I hope and expect is on our way to the Supreme Court. All the best. Bye-bye.